And to speak to the target on our back, immigrants have targets on their back every day. It's a risk we're willing to take.
Good evening. I'm Zach Friedel. I'm an assistant city attorney, and I'm going to talk you through the current ordinance, the changes in state law, and the proposed changes in the city ordinance before you. So first of all, the portion
the
of the
good
city
news
code
is since I control the microphone here, we're going to mute that dude because I'm tired of listening to him anyway. We're going to talk about Sanctuary Alliance Lawrence. These people are actually fighting these policies with legal assistance, and they're going to be incurring costs with that legal assistance. A lot of you people that have talked about supporting me monetarily, I want you to consider supporting Sanctuary Alliance. They're going to need some help offsetting legal fees to fight this little battle that the city is bringing to their doorstep. There was no need for these changes. Nobody had called anything out against us, and you'll see that as the meeting progresses. Enjoy.
But for the purposes of the ordinance that are here before you today, the goal is to bring the city into compliance with state law first and foremost. I'd be happy to answer any questions at the appropriate time.
So just to be clear, we have till July 1st to comply with the state, or they will compel compliance, I think is what you said. Okay, let's go ahead and open this to public comment.
Hello, City Commissioners. My name is Lacey Rowe, and I'm a member of the Sanctuary Alliance. I'd like to alert the Commissioners to a few of the most serious concerns within policy changes that we see today. First, I want to point out that undocumented immigration status is a civil violation, not a criminal violation. While the state policy prohibits the restriction of cooperation with ICE, it does not grant local police powers to independently address federal matters that fall beyond their scope of work. The fact still stands that state and local police have no authority to arrest and detain a person for a federal civil violation. Detention or extended holding by local police can constitute a warrantless arrest and a violation of the Fourth Amendment. Notably, Section 1-1004(2)A of the City Code does retain this requirement for the police policy to include provisions that prohibit arrest and detention based solely on civil cause. However, the police policy strikes this required provision in Sections 414.3 and 414.8, thus removing that protection from a violation of the Fourth Amendment. Additionally, poor wording within the police policy in Section 414.9 offers unclear interpretation on whether to provide public notice if it may interfere with federal activities. However, local police have an obligation to provide public notice for the sake of transparency in their own activities, and there is no reason for this to cause interference with immigration enforcement's ability to enforce federal civil warrants for federal civil violations. Notably, Section 1-1004(2)C, the City Code requires LPD to provide an alert to the public as soon as possible without violating state or federal law. Research consistently shows that if residents associate their police with immigration enforcement, then the fear of getting deported or losing a loved one can prevent immigrants and people in mixed status families from reporting crimes or coming forward as witnesses. And this not only inhibits the ability of our police to investigate crimes that fall under their jurisdiction, but it also diminishes public safety. Since immigration is a federal responsibility, cities and counties are not required to enforce federal immigration law in any way, and the 10th Amendment guarantees freedom from federal commandeering of local resources. Though the state policy prohibits the restriction of certain actions, the city can still offer guidance on appropriate use of city resources. If we don't assert control over local resources, then we're not only inviting uncertainty about whether our resources are being used efficiently, but we're also exposing ourselves to legal liabilities and risks which are not remedied by existing ICE compliance options. We can still highlight local priorities for the use of limited local resources. We can still ensure that the proper authorities are empowered to do their jobs. We can still do more to uphold human rights, strengthen community trust, and ensure fiscal accountability. With the help of an immigration policy expert and collaboration with the Sanctuary Alliance, the city can offer guidance on prioritizing fiscal accountability and thus the use of local resources for public safety and local responsibilities.
Thank
My
you.
name is Joe Taylor. I'm married to Eduardo Rosa Molinar, who is an American citizen from birth, born in Puerto Rico. But that didn't prevent him from being stopped by a police officer and for supposedly taking a curve too quickly off of Highway 10 onto 23rd Street. The police officer asked for his ID. He supplied it, driver's license. He had his KU emblem, pass. And the police officer said, "Do you have any more form of identification to show you're a citizen?" This is a police officer before all of this. This was 4 years ago. So my husband said, "I really don't think you have the right to ask that question." So this is a road I think you need to be careful about going down. Your police officers are already a little zealous about this, and this will give them carte blanche. Thank you.
Thank you.
So where we have stricken out some previous language, does that mean we're going to start doing enforcement on that? Just as an example, I'm looking at, let's see, 414.8, about halfway down. It says LPD members will not initiate contact with an individual for the sole purpose of assisting ICE. And the other thing they say is LPD members may not detain, arrest, or transport a person solely based on a civil immigration detainer or administrative warrant. The individual must have a criminal warrant issued by a court or underlying probable cause. So since we're striking that out, does that mean we will initiate contact in assisting ICE, in that we will detain even without a warrant?
Commissioner, this policy change makes no affirmative requirements of police officers or anyone else in the city. This is only striking prohibitions against that action.
Okay.
The threat occurred, but it was not a violation of policy.
So there's no plan to actually start doing this? Is that opens it up to be able to do that, though? Is that correct?
It's not prohibited in this policy any longer.
Okay.
More quick question, if you want to answer. I know we talked about the piece of immigration, anything following in regards to immigration law is civil. Can someone be brought, can someone be, if someone violates an immigration law, or there's a violation, an immigration violation, can they be brought up on criminal charges?
Commissioner, I'm not sure that I fully understand. Criminal charges would only be filed or pursued by the police department if a criminal law was violated.
I find it offensive that a city attorney would come up here and can't answer a simple question. Can you be charged criminally for a civil violation? How difficult is that, Brad? You're an attorney. That's not a tough question. But he obfuscates about it because he doesn't want to answer that, because he wants the target on your back so that you'll act the way he wants you to. That's wrong.
First, can we just say the actual consequences that are outlined in HB 2717 is that if we are not compliant, we will be put in a review to be compliant. So we are preemptively doing the work of the Attorney General by doing this. So that is our issue here about this not January, July 1st deadline, is if we are found to be in non-compliance, which means they have to bring it to us and say we are non-compliant, then they have to do a review.
Have we had any conversations, or have they contacted us saying that we have problem with your ordinance as it's written now?
I'm not aware of any such communication. No.
Other than that, there are no other penalties at this time. There's no fines. There's no legal action that is outlined in that bill. So we are being reactionary by doing this and striking language before we have an opportunity to get a review, and asking us to get a review in a week by a legal expert to look at The state bill, our current ordinance, police policy, and the revisions is an impossible ask. We are volunteers. We are unpaid here because this affects our community. This literally affects me and my family. That's a pretty big ask from the commission, rather than saying, let's do some good work on this, see what we need to revise, if anything. And if we fall out of compliance, the Attorney General can then do what they need to do and call us to be in compliance. That is the accountability measure that the state has put in. So I'm just confused as to why we are in such a rush when the consequence is a review of the ordinance in the first place.
I can respond to my thought, which is our oath of office says we're going to follow the state, federal laws. And if we have our attorneys telling us we have a law that violates the state, and maybe your position is that there's nothing in this ordinance that violates the state law. Maybe that's your position, that not one word needs to be changed. But we're being told law violates state law. So my concern is that I can't knowingly, have a law that violates. We can't have something on the books that violates state law.
And we're
So
saying
try to
that
accomplish that.
we are working towards that, but to rush this process
So
and just strike language.
is it your legal, do you have a legal opinion besides to contradict our attorney's legal opinion?
Yes, we've been working on this and have the legal expertise and the lived experience to tell you this. And we are also offering to provide an attorney to look at this.
Regarding any further consultation with specialized attorneys, I'm not aware that we're in a position to do that at this time at the city.
You are not providing that. We are. So can we please have the time to actually get somebody to review this and give them the space of more than a week, because we are being reactionary to a state law?
So Maria, what would that time be?
I would at least like a month to look through this, to work with city staff. It took us over a year to get this ordinance done. It's only been 114 days since this bill was proposed at the state legislature, and it was pushed through in an unjust way. And those are things that we're not placing blame on city staff or anybody other than state legislator, but we do need the time to do this in a way that will be effective and not take away questionable provisions. We've already put a lot of what has been stricken in the police policy that's violating the city ordinance. So there are already inconsistencies in what is stricken here. And I think we just are asking for a thorough review of this. And if July 1 rolls around and we're not ready, I'm asking the city of Lawrence to maybe take that risk and be non-compliant until we can do this right. And if the consequence right now is that the Attorney General may ask to review the ordinance, and we're already working to modify that ordinance, then on a personal level, I'm willing to take a risk like that. That doesn't sound like it's harming anyone. And to speak to the target on our back, immigrants have targets on their back every day. It's a risk we're willing to take.